Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I am your host. Today in the studio, we have John Kuntz. Now, John Kuntz is a former prosecutor with the Bexar County DA's office and has been in private practice since 2005, solely doing defense work, both state and federal. He's had over 150 jury trials. Regarding his personal background, he was born and raised here in San Antonio, went to Central Catholic High School, then Tulane University for his undergraduate degree, finally coming home to San Antonio to finish law school at St. Mary's. Welcome, John.
Thank you very much, Judge. I'm honored to be here.
I appreciate having you. I appreciate you coming in. I know that you are a regular listener of the show. Is that right?
Very much. I wish I could listen more.
Actually, we were talking about the last time that you said you had listened. You threw out an episode, the one with Monica Guerrero.
Mm-hmm.
I'm like, that was early on in the life of this podcast. You got some history behind you. Let's talk a little bit about your practice. You've been a lawyer for a long time now.
Yes, graduated and licensed in 97, but actually started in the criminal field back in 95 when I was in law school. I worked for the court administrator's office for a woman named Mercedes Kutcher, who I owe basically my entire career to. She was the district court administrator at that time, and she hired me as a law clerk. And our job at the time was to do writs of habeas corpus replies for all the district courts, which is incredibly dry and boring. But basically, people would complain, my lawyer railroaded me, and we would evaluate it and present findings to the judges, and then the judges would decide what to do. And then Mercedes then went to the DA's office, and she brought me into the DA's office in 99, a couple of years later.
So writs are basically somebody has already gone through the appellate process, the direct appeal, they've exhausted all of those, they file some sort of motion with the court, the judges get them, and then you would do the research and potentially provide the writing.
Sure. One that stands out was, and I can't remember the defendant's name, but he was a jailhouse lawyer extraordinaire. And his writ was not a simple or small one. What I distinctly remember, and what became kind of part of the Court of Criminal Appeals opinion, was that he called himself a writter. RWRITTER. And he used that phrase 50 or 100 times throughout his writ, that he was a very experienced writter. And so I used that in the reply that the district court judge would send to the Court of Criminal Appeals. And the man at the Court of Criminal Appeals at the time, who did the writs for a million years, his name was John Jasuda. I'll never forget, called Mercedes, my boss, and said, I have got to talk to the person that composed this order, because I guess he found it very humorous how I had woven the writter part into the reply. And so there were a lot of, actually, again, it's kind of a boring area of law. It's a very arcane, very seldom used area, but there actually was a lot of humor in that stuff sometimes too.
You're obviously good at it.
Well, it was fun. So yeah,
you were a good opponent for the writter.
Yes, the writter. Yeah.
So you did that. You finished law school. What year? 1997.
97. Took the bar that summer. Thank God passed it on the first try, and hung a shingle like so many naive young fools graduating from law school. Very quickly realized that was not my path to riches. So I interviewed for a job in Houston in the late summer of 98, and accepted the job. They offered me the job. I accepted it. And by the time I actually moved to Houston a month later, I learned that the law firm had devolved and all the partners were suing each other. And no one had informed me of that when I signed the lease, moved over, anything like that. And so I worked at that firm for, just 5 or 6 months. And Susan Reed got elected that fall. That would have been the fall of 98. And I saw that Mercedes Kutcher was going to be the administrative district attorney, meaning the number 3 person in the office. And I reached out to her. She said, "Come on back, John. We'll get a job for you." So I quit that job, moved back to San Antonio, and still didn't get hired till September. So I hustled appointments and things. But then I did get to the DA's office and enjoyed it tremendously. Had some wonderful judges.
And then you went on your own?
Well, I was hired by a lawyer actually away from the DA's office, and I was ready to go. I was a second chair. At the time, there wasn't much turnover above me.
That's when it took a long time to become a second chair.
Yeah, and it would take even longer to be a first chair. And I thought, well, I think I'm ready to go. And so I went and worked for a lawyer on April 14th of 2005. And I remember the day because it was day before tax day. And I knew by lunchtime on that day, that first day, that this was not going to last. And so I worked for him for approximately a year. But then I thought, nah, I don't want to risk my law license by continuing to work for this person because he would make promises to clients that I knew we couldn't keep. And that was always a problem for me. But then, so I've been on my own since mid 2006.
Well, I know in 2008, when I was running for this particular position, you had a pretty big jury trial. It was making the news. It was an interesting case. You want to tell us a little bit about that case?
Sure. So a cousin of mine who's an attorney here in town had been telling me for months about this very difficult client that he had. It was a murder case. And, he just, John, I think I might need some help, but the judge won't appoint a second chair and all this. And I said, well, if the judge, and it was your predecessor, I said, well, if the judge will appoint and you want me, I'm more than happy to accept it. Because my cousin kept saying how kind of loony this client was and how difficult and all this sort of stuff. And I thought to myself, loony and difficult. I've dated loony and difficult. I can handle this. So
another day in the life.
Yeah, exactly. So Albert called me one day and said, hey, the judge agreed to appoint you. And I said, okay, great. I'll go see the guy this afternoon at the jail. Okay. So I went over to the jail and, request him. And do you remember where we'd go visit before the Zooms and all this sort of stuff at the jail? We'd walk in and there was obviously a big piece of glass and a metal little round stool to sit on and stuff like that.
You walk in through the side.
Yeah.
And then there's this hallway and there's maybe 6 attorney booths.
Right.
Very small. You could smell the air coming in through from the inside of the jail.
Not a great smell. And so I knew nothing about this defendant other than I don't think I'd even seen police reports or anything. I just wanted to go introduce myself, say, hey, I'm going to be here helping your current lawyer. We're going to be, now you've got 2 very good lawyers on your team. So the door to the jail side opens up and this very small little man pops his head sort of sideways and says, well, I won't use the words he said, but basically, who are you? With a couple of other choice words in the middle there. Uh-huh. And I said, oh, I'm John Kuntz. I'm going to be helping your current lawyer. You now have both of us on your case. We're going to do everything we can to help you. And he proceeded to scream and yell at me in the vilest, foulest terms you could ever imagine. And it was so... The passion and the rage that came out of this very small person was something that Hollywood doesn't even have a clue as to how to do. It was so obvious to me why in years past people would say that someone was possessed by the devil, because it didn't seem human. It didn't seem of this earth. And the rage and the anger were so, it was perplexing because he's just meeting me and he's screaming and yelling at me for some reason. And it was very disheartening, quite frankly. So when I left, I called the other lawyer and said, hey, I just met him. Holy cow, this guy really is a problem. And he'd been evaluated by the doctors at least once or twice at that point. And I do, to this day, I think both of us lawyers would say that we felt like he had to have been insane at the time of the offense. let me back up. He was accused of stabbing a benevolent neighbor something like 80 times with either scissors or a knife. It's been 17 years.
He was charged with a murder case.
Charged with a murder. And he'd been to prison. He was 49 years old at the time, I think, of the offense. And we were able to determine that from the age of 10 to 49, he'd only spent maybe 2 or 3 years on the outside total.
Mm-hmm.
He'd been a ward of the state and the juvenile system and then the criminal justice system as an adult the whole time. Realistically, he could not function. I mean, I think it would be very simple and easy and truthful to say that he was institutionalized basically by having been raised in the system. And in talking to his family, we think some terrible, terrible childhood trauma had occurred. But the interesting thing about this guy was he had a great sense of humor when he was in a good mood. He was highly intelligent. He was mean, the meanest person I've ever met, but he was highly, highly intelligent. And he had a cutting wit. And one of the many things that were very funny were he called me a Pinocchio-looking MFer on the record, which your predecessor, I believe, has framed in his office somewhere. And he called the other lawyer something else that was pretty funny too. He was just hysterical, but he was so mean. So fast forward, the trial's a month or two out. We have some settings. We're asking him to be evaluated again. One of the problems was he shot himself in the foot because the prosecutors tossed his cell one time, and tossing a cell is prosecutors will have the ability to tell the jail staff, hey, go look at what this guy has in his cell. They're not necessarily looking for knives or anything like that, but what they're also looking for is letters that they're writing or letters they've received. Because sometimes guys are writing their girlfriend or wife saying, yeah, I know I did it, but I'm not going to admit to it type stuff.
Mm-hmm.
So they tossed his cell and he was writing another inmate a how to act crazy.
Mm-hmm.
And he was on, I think, number 5 or 6 of 10 at that point by the time. And so the doctor said, well, clearly he knows what's up. He knows exactly what he's doing and so he is competent. I still think he was insane at the time of the offense probably, but so there was not a doctor in town that would find him incompetent because.
So when you say he was being evaluated,
mm-hmm.
He was being evaluated to see if he was insane at the time of the offense and competent, or whether or not he was competent at the time you were getting ready for trial.
I believe prior to me being on the case, he'd been evaluated for sanity and was determined sane. I could be wrong about that. Mainly, we were focused with competency because he wouldn't confer with us. Basically, he would scream and yell at us the whole time. Sometimes it was nonsensical and just rage for the sake of rage. So he was evaluated, I think, by 3 doctors, maybe 4. And the judge at the time was doing everything. He knew how difficult this guy was. And
sometimes folks think somebody's found to be incompetent, somehow or another their case gets dismissed.
Right.
You want to explain to us how that works?
So competency, as people may or may not know, can be a shifting target.
Mm-hmm.
And for most of us, we're competent every day. But for some people with mental health issues, competency can be dependent on a variety of things, whether chemical imbalances in their own body or chemicals that they're using. And so ideally, if someone is determined by the doctors to be incompetent, the goal of the court system is then to try to restore them to competency.
Right. So when somebody's not competent, everything stops in the court system.
Correct.
And the idea then is, because they have a 6th Amendment right to help their lawyer,
right?
The inability to help their lawyer means that they're not competent. So then they try to restore them to competence.
Right. So it's basically hitting the pause button on the criminal case.
Right.
And so it literally hits the button. They try to have the person, they send them typically to the state hospital, either here at San Antonio State Hospital or Vernon's. But even that opens up another can of worms because currently it's a year to year and a half wait.
Right.
So you sit at the jail, if you're an inmate, decompensating in theory and not getting any better. Yes, the jail tries to keep you stable and stuff, but it's not there. They do now have that jail-based restoration program, but that's a much newer program.
That's sort of like an outpatient,
but in the jail.
So now they have it in the jail as well.
Yes.
Yes. And so when it comes to issues of them having to wait for a state hospital, that really is a state issue, right? The state of Texas
absolutely
shut down a lot of these bed spaces. And as a result of that, now we're having to wait.
I think chronically and historically, they had underfunded that system.
Mm-hmm.
And I do believe about 3 legislative sessions ago, they finally allocated a lot of money for it. And they've been expanding. For instance, the state hospital here, they have that beautiful new building or buildings. I believe they've done that statewide where they have tried to increase capacity and hired more people and so on. But so in essence, back to the competency thing. So if the person is restored to competency, either at the jail through their competency restoration program or at the state hospital, then they come back back and a new determination is made. Okay, well, the hospital thinks he's been restored, but we want to have the county will have its own doctor evaluate the person. And then at that point in time, if the person has been restored to competency, then the pause button is hit again and the case is back on play. And so all the settings come back up and so on and so forth.
So when it comes to this defendant's name is Richard Jett.
Richard Jett, Jett. Yes.
So when it comes to him, he had already been through that process
several times.
So somebody can be found to be not competent, go through the whole restoration process, come back, and then a month or two later, they could be found not competent again. And then the whole thing starts over again.
Exactly.
You had talked about how the state had his cell toss. And generally speaking, when somebody's already in the court system and prosecutors are looking for some items that may be of use to them that are outside the attorney-client privilege, what they'll do is they'll come to a judge. A judge will allow that. And oftentimes, everything that they get within that jail when the cell is tossed is brought to the court for an in-camera inspection, which is basically a term of art where a judge inspects everything to make sure that there is no attorney-client privilege involved and whatever materials are found. Outside of that, generally, whatever is found can be used against that defendant. So something like that happened with Richard Jett.
Right. And they had found the letter he was writing to someone else in the jail stating how to act crazy. Mm-hmm. I believe it was entitled How to Act Crazy, if I remember correctly. And like I said, he had already gone, the steps he had already been using in dealing with the doctors in the jail, I think he was on number 5 or 6 of the 10 or so that were on the list. So again, when the doctors heard that he very knowingly was trying to act crazy, they said, well, this is clearly someone who knows exactly what he's doing. And we're not about to find him incompetent.
We go through a lot of those issues in the court system generally, don't we? I mean, as practitioners, that was a defendant we had in the court several years ago, maybe a decade ago. He was charged with a murder case. And he was, after the fact, we heard phone conversations that he had with somebody telling them they can't try me unless I'm dressed appropriately. So they brought the nice shirt to him. He was in the holding cell in the back here in the courtroom. Before the jury was about to walk in, he takes off his shirt, puts it in the toilet, flushes a toilet, causes a flood then, which created maybe a 2-hour process and having to get it all cleaned up, finding him another shirt, tell the jury to go do something for a couple hours, brought them back. He did it again. After I had warned him on the record, hey, if you choose to take your shirt off and flush it down the toilet, then it's going to be your choice to be in this jury trial without a shirt.
Yeah.
So what happened was he did it the second time, made the jury wait. So when he came back out, he asked for a shirt. I said, well, you've had the opportunity. You were warned on the record. Let's bring in the jury. So then the jury panel comes in. And of course, this young man had tattoos all over his body. They're coming in immediately. They're focused on this guy sitting next to the attorney without a shirt, tattoos all over their body, wondering what the heck did this guy did. A plea followed pretty soon thereafter. Right. So we go through a lot of these issues.
Right. There are people. In fact, I think there was someone in the 227 today trying to play the game. And so there was something along those lines happening. And so what they did was they bypassed him for another defendant to try. But I overheard some staff talking about they're going to have to fix this, not allow him to kind of play this game and delay his own fate. But yes, these are things we have to deal with all the time. Those defendants who think that they're smarter than the system rarely are, as we know, and eventually they do run out of options. And so back to Richard. Richard tried everything. So they brought him over for court one day, and he smeared himself in feces.
How did he do that?
Thankfully, I wasn't there for that, so I couldn't really say exactly.
Bring the popcorn.
but I have an idea as to how he did that, Judge. So another time he had snuck a pen from the jail over to the holding cell here, and he had kept the pen in an orifice of his body so they didn't detect it when they searched him. And then he used it to write a swastika on his forehead. Some other statements, maybe something along the lines of 399 or 379th is a joke or something terrible. And so I think it was on that day that we were having a hearing. The jury hadn't been selected at that point. It was probably the day before jury selection or possibly the morning of jury selection. So we were having a hearing about that, and I was standing next to him. He was in handcuffs and shackles. He was addressing the judge himself and was getting more and more animated. And the next thing you know, he lunged at me. Thankfully, he was cuffed and shackled, so he wasn't able to actually touch me. And the cameras were there, so it kind of recorded this, and I've been made fun of once or twice for this. But I sort of just stepped ducked out of the way while he kind of came at me, and then a couple of deputies tackled him and made his life very difficult for a few minutes. He voluntarily absented himself from the trial. When we selected the jury, he wasn't there because he would not tell the judge that he would agree to behave. As you can imagine, jury selection was not easy when you don't have a defendant there. And I'll back up even a little further. This was a case that, and I'm not saying this just as a foolish optimist, this was a case that we actually believed we had a chance at getting a not guilty or a hung jury because the police had done such a terrible investigation and they really just kind of did a thing. Well, it must be him, even though there was information about 4 other people around the victim's house earlier in the day that looked like they were trying to break in and all this sort of stuff. But Richard was his own worst enemy. And every morning of trial, and the trial went over 3 weeks. And it was kind of a funny trial because, well, first of all, every morning would start out with the judge calling on the record, calling the jail and talking to Richard directly saying, are you going to behave or not? And some mornings Richard would say, yeah, I'm good. I'll be there. And he would be. He'd sit there and he'd be fine. They'd have him in the Hannibal Lecter chair, in literally a chair where he was strapped down. He had a spit mask on. He had the sort of face guard.
So this is during the jury trial.
This is during the jury trial.
With the jury in the box.
Yeah, not the warmest feelings I'm sure they had for him.
What led to those types of restraint?
Well, again, him trying to attack me in the courtroom and smearing feces and doing all these other things and sort of making other threats at different times. Okay. And then some days he would say, nah, Judge, I don't feel like behaving. And so they wouldn't bring him over. So he would be there sometimes. He wouldn't be there all the time. He actually decided to testify, which was a very interesting choice of his, and one that we strongly tried to dissuade him from doing.
And so folks know when it comes to trial strategy, generally the attorney has the right to direct the trial strategy, but certain constitutional provisions allow those that are accused of a crime to have choices. And one of those is, does the defendant testify or not? That was his call.
And since he had been ruled to be competent by the doctors, he could make that decision. And so I agreed that I would question him. And from counsel table, I began to ask him questions. And I think one of my first questions was, Richard, how are you doing? And he said something along the lines of, I'm strapped down like a dog. How do you think I'm doing? And I tried not to laugh. And he proceeded to tell this tale of a band of ninjas basically breaking into the old man's house, the decedent. He just said some absolutely absurd things that I had to try not to laugh because this trial had been going on and he was doing wacky stuff almost every day, that all the news cameras were there every day. And the courtroom was filled every day with spectators. So I'd look out in the audience and see these people watching this trial because it was better than television, quite frankly. Richard, needless to say, was convicted. And on punishment, again, we had the punishment being the second part of the trial where the prosecutors get to present any evidence of any bad act that the person has ever done. And he had a long criminal history, so they were putting on victims of other crimes of his. And one of the victims was going to need to identify him. I think she was a victim of a robbery he'd committed. But again, that was one of the days where he didn't want to be compliant, but he still had to be identified. So they kept him back in the holding cell so away from the juries, and in the Hannibal Lecter chair, the prosecutor walked the victim up, on so-and-so day. Did someone bring a gun or knife or whatever it was? And at the time in which the prosecutor was asking, would you be able to identify that person if they were in the courtroom, the door to the holding cell opens up and the deputies wheel Richard out and he starts screaming at the jurors, well, the dirty dozen, look at you, the dirty dozen. And I'm trying not to laugh. Everyone's trying not to laugh. And the witness says, that's him. And then they just wheeled him right back. It was like something at a fun house or a carnival or something like that. Here's the mean guy, pull him out for a minute and then put him back in.
They brought him in just for the identification.
Just literally for 5 seconds for the identification. Well, the dirty dozen. I'll never forget that.
I've never had a jury trial where somebody has had to be in a Hannibal Lecter chair with a face mask on and restrained. So that's a very unusual scenario. All right, let's do a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome to the Q&A break. I'm here talking with John Kuntz, attorney extraordinaire. We have a question. Why are we allowing court-appointed attorneys who refuse to protect the interest of their clients to keep from being removed from cases they just can't plead out? It makes a mockery of the system. Attorneys who are gaming the system should not be allowed to continue to represent indigent offenders. What do you think, John?
So if I'm understanding that question correctly, I think what they're saying is, why are we allowing lawyers who maybe aren't willing to put the work in and perhaps try a case? Why are they even on the wheel to get appointed?
Mm-hmm.
And I do agree with that. For many years, I've worried about the level of representation of some lawyers. The argument that I've heard in terms of, well, why does this person get appointments when they should not be representing indigent clients or any clients? The argument is, well, they have to put food on their plate too. And my counter argument to that is that defendant's rights trump that lawyer's ability to make money. I'm sorry.
Regardless of the level of offense.
Right.
It could be a very small Class B misdemeanor.
Absolutely.
It could be a death penalty case. It's always important that you have competent Sixth Amendment representation.
Absolutely.
In indigent defense systems generally, an indigent defense is referring to folks that cannot afford their own attorney, so they have to have a court-appointed lawyer represent them. There are different types of system in the United States. Here we have something called the wheel, and the wheel is an assigned counsel type system where randomly attorneys get on that particular system. They get appointed defendants, and then they represent them in court. We have just improved that through the managed assigned counsel to oversee that wheel. Up until about a year or two ago, we were at an all-time low with attorneys that were on that wheel. We simply did not have enough lawyers that were willing to take court-appointed cases. That started about the time that COVID was starting to come to a conclusion as it relates to how it affected our jury system and our court system. I think it would be a good time to bring our MAC director back to talk about some of the ways that they have revamped how court-appointed attorneys get assigned, how court-appointed attorneys actually make it onto that wheel. They have been removing a lot of attorneys on that system within the last year that they've actually overtaken that process. Prior to that, the judges handled it on top of all the other administrative duties that judges did, and it was difficult for judges sometimes to remove certain colleagues that they had a lot of respect for over the years. And so with the managed assigned counsel system, I think that we're sort of starting to address those kinds of issues.
What kind of person would I be, or would you be, to treat people differently just based on their wealth?
That's sort of antithetical to what our system is.
Right. Wealthy people sometimes are the biggest pains in the neck. So as we know.
Well, that was a good question. Thank you for asking that question. We enjoyed answering it. Please continue texting your questions into the show, and we'll continue to answer them as they come in. Let's get back to the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back to the show. I'm here talking with John Kuntz. Well, I came in after the, I guess the direct appeals were over. So I came in and I started getting all the letters on the writs, and I had no clue who this person was. And they would just, put them in the file if they didn't need attention, or send them to our administrative counsel if they did need attention. But I'm thinking there's this guy out here who's saying some pretty mean-spirited things towards me. I don't know who he is, but frankly, at this point, that's just kind of how it worked.
They were mean-spirited, but also very humorous. And one of them started out with, "Every day I open up the San Antonio Express News, hoping to see your name in the obituary," and things like that. And I mean, it's mean, but it's actually pretty funny. The guy was just ridiculous. And now that I think about it, we have not gotten letters from him in some time. I'm a little disappointed. I wonder if he's still alive.
We've had all types. I've had defendants that have written me from the jail with cases pending with maybe a playing card with a king on it, and sending something of themselves with, something different. And, I had one guy that drew a picture of me 100 times on a piece of paper with a Fu Manchu type mustache. All sorts of interesting types of correspondence we get from the jail. What is your perspective like in representing folks? Like, what's the experience like?
I'm a bleeding heart defense attorney, and so I always try to help my clients as best I can. I can't lie. I'm a human being too. And when you have someone that's that difficult to deal with, it makes your job, especially in that case where we thought we might be able to win. If he could just keep calm during the trial and act like a semi-normal person, maybe the jury, would feel sorry for him. And because there was plenty of error on the police department, plenty of, from our perspective, prosecutors might disagree, but from our perspective, there was plenty of reasonable doubt in terms of Richard's involvement in this case, but he wouldn't. And so I feel sorry for Richard. Once I left that first meeting, it was such a strange, the one at the jail where he screamed and yelled at me and was so strange. I knew he's not right. This is not the behavior of someone who is rational. They might be competent, but they're not rational.
Right.
And they have some deep-seated problems that I can't fix. I'm just a lawyer. I'm not a psychiatrist or a psychologist or anything like that. So, this very morning I had a hearing in front of Judge Carruthers on a young man who has been in and out of the mental health system for years, and he's going back to the state hospital now. And I feel terrible for him. His mother's a very sweet woman, and I know he wants to get out, but he has violent tendencies. Everyone at the jail and the state hospital has known him for years because of his outbursts and all sorts of stuff. And I don't know that he'll ever, I'm optimistic, but I don't know that he will ever be able to regain competency. Now, the flip side to that, just this past Friday, a few days ago, I got a call from one of my favorite clients who I'd represented. But anyway, he called me this past Friday. It was great hearing from him. And so those are the types of stories that I love. This is one of the rare businesses, well, at least for me, where I don't ever want a repeat customer.
Right.
If I own a restaurant, I want people to love my food and come back. If I own an airline, I want people to fly my airline again. If I own a car dealership, whatever it is. And especially now in this more recent era where we have so many treatment options, whether it's mental health, substances, combinations, whatever, I always feel like I've somehow failed if I get a client that calls me a few years later and says, hey, I'm back in trouble and, sort of thing, because I want all of my clients to be safe and healthy today, tomorrow, next week, next month, and I understand, certainly doing this job for as long as I have, and I'm sure you have the same perspective, that mental health and or substance issues are not something that can be fixed overnight usually. Ultimately with substance issues, it's the person has to be ready.
So as an attorney, you're dealing with folks in a way that you have to exercise great empathy. You got to show good humanity. You got to have some concern, be that counselor at law that is in our title. You do represent folks sometimes that are accused of violent or sexual natured type crimes. Is there some sort of stigma involved with representing individuals like that in your practice?
Of course. I'm sure you experienced this when you were in private practice. When someone finds out that you're a criminal defense lawyer, first of all, they want to hear who's your craziest client, or what's the craziest case you've ever had. The other question is the next follow-up question is, how can you represent those child molesters,
right?
Whatever sort of thing.
What kind of answers you give them?
It is the standard answer, of course, is everyone's entitled to competent representation, and I try to provide more than that. I want to be the best lawyer that I can be, and I don't like to lose. And so one of the questions that oftentimes I will ask them is, have you ever heard of anyone being exonerated down the road? And of course, everyone has. In this day and age, everyone's heard of people being exonerated. And it's like, well, sometimes that's those people. Sometimes these are false accusations, and it is something that no one would want to be charged with. I was talking to a gentleman before I came to court this morning. There's an allegation that's been made. He's never been in trouble. He was a successful businessman. And I told him, I said, you'd rather someone said that you murdered someone, because sometimes there's an explanation for a death, right? Maybe it was self-defense. Maybe it was but yeah, those are always interesting questions. Honestly, Judge, I try to sidestep people that seem to be coming at me a little hard about how can you represent those people, because I know I'm not going to be able to win that conversation generally. They're very rarely do people have the ability to be receptive to my answers.
I had a conversation with a couple of folks this weekend, and we were sort of talking about trials and defendants and the criminal law and how the court system works. And what I said is oftentimes people that are accused of a certain crime may be guilty, but the question is, what is it that they're guilty of?
Right.
How do you define it? What category do you put that in? So many times the trial in and of itself is not necessarily a question of what this person did, but more of what is the appropriate punishment? What's fair in this case? Right?
Sure.
What is it that they really had in their heart? What is it that really resulted? What is it that's fair? And generally speaking, I think the law gives us an opportunity to do what's fair, as long as both sides, state and the defense, does everything that they can do to represent their clients effectively, ethically, and all those other types.
Absolutely. And you bring up another point, which is sometimes we pick up a DA file or look at discovery and go, well, I think that my client committed a crime. It's just not the crime that he's been charged with.
Right.
And I've had a couple of opportunities in jury trials to make that argument, and it's always been successful, but he's been found not guilty each time. One was captured on video, an assault. But the complainant, when she testified, she was very tough. And she really couldn't articulate on the stand. She articulated that she'd been in pain. However, we had done our own little sleuthing and found some posts of hers online from a day after this alleged incident where she's at the gym lifting huge amounts of weights. She was a power lifter sort of as a hobby. And for her to say that she had these injuries didn't make any sense. So I literally got up and told because it was captured on video and it looked shocking, he pushed this woman into a wall at the airport very violently and like ran at her basically and then pushed her. I told the jurors, I said, you might think my client's a jerk and he does jerky things. And I'll never forget, I used those words. I said, he's a jerk and he does jerky things, but that's not what he's charged with. You cannot in good faith think that she had a bodily injury here. This is not, look at these pictures of her just the day later, 2 days later, whatever it was, for her to be complaining of all these pains and all these injuries and stuff. First of all, where are these injuries on these photos from a day later? And secondly, how was she able to do the things that she's doing in these photos if she really was injured? So yeah, the jurors didn't like my client, but they found him not guilty. So yeah.
And representing these types of folks, right? Folks that are accused of crimes, folks that are accused of violent or sexual type crimes. Are there any moral or ethical considerations that you got to consider that you would advise folks in the system that don't understand how it works to be a lawyer? These are the kind of pitfalls that we need to watch out for.
Well, I mean, I would say every now and then we'll get clients that will tell us one story and then a week later, a month later, tell us, oh, no, it was actually very different than the first story. And so you go, well,
every now and then.
Yeah. No, thankfully people are generally pretty straightforward with me. So I think, I'm kind of a no nonsense person and I think that people pick up on that fairly quickly. And so they also understand that I am not, years ago I had a guy say, okay, so I know what your fee is, but how much to get to the judge?
Right.
And I immediately said, get the heck out of my office. I don't want your money. I don't want to talk to you anymore. Get out of here. Because I'm sitting there thinking, first of all, I'm not going to deal with this guy. And secondly, what if he's wearing a wire, sort of thing? I don't want anyone to misconstrue that I'm even having this conversation, even contemplating this. I'm like, get out of my office. I will. He's like, whoa, wait. I said, get out of my office. I'm not talking to you ever again. Leave. Because, and there are some people that think that in this day and age that sort of thing is still done.
Right.
And you think to yourself, with all of us holding recording devices on our person all day long, how in the world could we be expected to get away with bribing someone? How would that even be possible? Even if there was something that a lawyer was contemplating doing. So,
first of all, yes, it seems very difficult to think that anybody could conceive that something like that could be going on nowadays. Right. So when it comes to representing folks, I do remember they would come in the office back in the day and I would say, what happened? They'd give me a story. And then invariably I look at the police report and say, okay, you left this very important piece of information
Right.
out, and this is kind of an issue. And
Right. No, for sure. That is always a fun one. And the nice thing now is, since we get electronic discovery, sometimes the first time I'm meeting the person, I already have the report.
Right.
It's certainly on court-appointed clients. Say if I got appointed to someone today that got arrested last night, I will have the report by the end of this week at the latest.
That is an advantage.
Possibly even tomorrow. So by the time I have my video conference with him, if he's in jail or the meeting in my office, I will generally have that sort of stuff.
Let's go back to the issue that you dealt with, Richard Jett. And I'm sure a lot of your other high profile clients and cases, you've had a lot of high profile cases. And so when dealing with those types of issues, where the cameras are in the courtroom, you got the media that's reporting on those types of whatever's going on during the day. How difficult is it, in your experience, to counterbalance what the media has been saying, or to counterbalance the narrative that is used to sell papers, to sell TV time, those types of issues?
It's almost impossible. As one of my old bosses at the DA's office said, you never fight with the media because they buy ink by the barrel. And that's definitely an outdated phrase now. So we'd have to equate it to something on the internet.
You got to figure out how to renew that.
Right. I don't even talk to the media when they call. I have a couple of cases right now in particular where they've been calling us periodically. I mean, from as far away as Los Angeles and Atlanta and Washington, D.C. about some kind of high profile stuff. And so, but I never even talk to them because, first of all, I don't want to feed the fire. And also my ego is not such that I feel like I need to be on television or radio or anything like that. Necessarily, I'm very flattered to be here, but that's not, me. I'm not seeking attention because I think sometimes that actually hurts our clients.
I was going to say, is there anything that you could say that would be a benefit?
In this day and age of TikTok and everything else, not really. I'm learning that on a couple of cases right now where there are some theories going around about one of them in particular online that are so far-fetched and ridiculous and crazy. And this case has tens and tens of thousands of views and likes. There are people online, not even from San Antonio, who will review basically the old D page, although now I don't know how they're doing it on Odyssey, and say, oh, look, a motion was filed today. Let's talk about what that motion was. They have no connection to San Antonio, this case, whatever, but they're making a living analyzing high profile cases around the country, sort of thing. And it's very interesting. But again, I just don't think it's generally in our clients' interest. When you watch these shows like 48 Hours or 2020 or whatever, and they'll follow a case, through the trial or something, and sometimes the defense attorney will talk to them. I mean, I guess it makes a little bit of sense to sort of lay out what your defense might be, but I don't know that I even want the prosecutor to know that at that point. And I certainly don't want the media, some third party or third, fourth, fifth, 20th parties to know about it.
Yeah, it's got to be difficult for a defense attorney.
Mm-hmm.
You've handled a lot of cases, and as we talked about, there's a lot of emotion that goes in representing people just because we're human. Are there any cases that you have worked on that has left some sort of lasting effect, impression on you that's altered the way you feel about things?
Wow.
Were you expecting to get that kind of a deep question?
Yeah, well, let me, I'll tell you about my favorite client, my literal favorite client. And I love her to pieces, and we've been friends now for last month was 12 years that she's been sober. She was on a federal case. She'd gotten caught delivering drugs to an undercover agent, a lot of drugs to an undercover agent, and they arrested her.
Mm-hmm.
She was 53 years old at the time. She had been a daily methamphetamine user since the age of 13. So for 40 years.
Mm-hmm. I
I was 40 at the time that I started representing her 12 years ago. So every day that I'd been on the planet, she'd been using drugs. She never quit. And she went to prison, state jail. Even then, she was able to get drugs, as we know, and especially for women. Unfortunately, they have to do things to get those drugs that no one would ever want anyone doing. But when you're in the throes of an addiction like that was as severe as hers, she's been shot, she's been stabbed, she's been raped. She's had just the most horrendous life. But when she got arrested in the federal system, she begged the judge to send her to rehab. She'd never gone to rehab. When I was appointed to represent her, I honestly thought, what can I possibly do to help this person? She's been a drug addict for every day that I've been on this planet. Well, I didn't do anything. She did it all. She begged to go to rehab. She went to the Alpha home, got sober.
Mm-hmm.
She was there for a few months, then went to a sober living house, then became like the house mom, sort of. She was quite a bit older than most of the other women in the, typically younger, in their 20s and maybe 30s in these homes. She then if I remember correctly, got on the board of directors of Cross Point and Oxford House and things like that.
Wow.
Went to school, became a licensed peer-to-peer counselor.
Mm-hmm.
She's been working at the Haven for Hope now for over a decade. She has also opened 2 sober living homes. She has a son that's been very successful in his business, and so he's helping finance buying 2 homes here, one for men, one for women. And she's helping, I think each home houses 12 or 16 people at a time. And so she's just the most remarkable person that I've ever met, honestly. And I honestly feel like she was put in my life at that time to kind of reignite the flame in my soul. And I do think God put her there for me to kind of say, John, people can change no matter how much they've been through, no matter how terrible their life has been, no matter how many years they've been using drugs, no matter anything. If they want to change, they can. And so I use her story all the time. She doesn't mind me using her story or her name, but I tell people that want to hire me for their child or their sibling or whatever, I will put them in touch with her oftentimes, and she'll help put their minds at ease about things or help explain why their daughter or son won't just snap out of it, sort of thing. And I had another friend that I grew up with who got into heroin when we were probably 14 or 15 and was an addict for about 17 years till his early 30s. And a few years ago, he called me, and he lives in Austin now. And one day I asked him, because I was dealing with a client who I just couldn't wrap my head around why this client, to me, they've hit rock bottom over and over and over. I mean, waking up in the gutter practically, every day and has a family with resources and stuff. And he said, everyone's rock bottom is different.
Mm-hmm.
And that's so true. There's so many people. There are people that we know that have gotten drunk once in their life and said, oh my God, I hated the way I felt. And I embarrassed myself. I will never touch alcohol again. And then there are people that we know that literally wake up in the gutter day after day after day after day and keep going back to that well, keep using the drugs or the alcohol or whatever. And they just can't break themselves free. So my favorite client, the one who was an addict for 40 years, that was such an important time for her to deal with her, because she absolutely turned her life around in ways that I never could have anticipated. And she's been on this upward trajectory ever since. She's just the most remarkable human being.
The resilience and power of the human spirit.
Truly.
We get to see that every day in our profession. John, I've enjoyed talking to you today.
Well, Judge, it's been an honor, and this has been a lot of fun.
Yeah, we've talked about you coming on a little bit. I'm glad you could finally make it. Any last words that you may have for our listeners?
The criminal justice system is a very complicated organism, but there are many people in the system doing everything they can, whether they're prosecutors or defense attorneys, to make sure that it operates in a just way. And that's the important thing to remember. I hope that people understand that certainly in Bexar County here in San Antonio, this is not a corrupt system. This is not a perfect system, but it is not a corrupt system. And I wish people would have more faith in the criminal justice system, because I do believe that overall it is obviously the best system that we can come up with. And I love coming to work every day. I'm one of those guys that does, and I know a lot of people that do. And I just wish people didn't have such a negative opinion of our system.
Words of wisdom, John. Thank you so much for those. Well, we've reached the end of this episode. Thanks so much for listening. Don't forget to subscribe and keep sending in those questions. Remember, you can now text the show by clicking Text the Judge to send in your insights, reviews, and your question. I'll mention them during the break. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.